Today, the U.S. Supreme Court delivered a huge win for Native families, one some activists say is reaffirming the sovereignty of tribal governments. The court ruled 7-2 the Indian Child Welfare Act is constitutional, despite one Texas couple arguing the federal law is a form of racial discrimination. Griffin Rushton took a closer look into this case for us today. And Griffin, so this argument is really focused on Native kids who are in the foster care system.
It is, but some activists, as we were mentioning, believe that there is a bigger issue at play here.
Definitely.
The Indian Child Welfare Act, or ICWA, essentially states that Native governments get to decide what happens to their children who end up in the foster care system. Let's take a Navajo child up for adoption. A Navajo child up for adoption, for example. ICWA makes sure that Navajo leaders would be part of that placement process, likely placing that child with a Navajo family, but that's not to say that that child couldn't end up with a Hispanic or white family, for example. Activists say today is really preserving that decision-making power, and that's the big win that they're celebrating.
My first reaction was to burst out in tears of happiness.
Cynthia Shavers is a longtime advocate of the Indian Child Welfare Act and knows the Supreme Court's decision was not just about foster children.
If ICWA were to be overturned or dismantled, that could mean serious threats to the sovereignty of tribal nations all across the United States.
Shaver says the law was passed in 1978 to end the U.S. government's decades-long practice of forcibly removing Native children from their ancestral homes and into mainstream society, often through boarding schools.
We know that 25 to 35% of American Indian children were being removed prior to the passing of this legislation. At least a quarter of our communities were being taken and forced into adoptions and other situations where they never may return to their home community.
The law specifically states it's meant to promote the stability and security of Indian tribes and families. That's why it says Native children up for adoption should be placed with family members, other members of the child's tribe, or other Native families first.
We know that tribes know what is best for our citizens and that we need to be involved in decisions for our citizens.
In a 2017 federal lawsuit, several white couples who adopted Native children argued the process is a form of racial discrimination and unconstitutional. Tribal leaders fought back, saying Native Americans should be viewed as a political class, not a racial group.
The difference being that we are sovereign nations with special rights as sovereign nations protected through the treaties and the U.S. Constitution that allow us to continue to survive.
Shaver says the High Court's decision continues to acknowledge that sovereign status and their right to survive through their children.
I just really want to stress that there is nothing that is more important to tribal communities and to our continued existence than our children.
Yeah, Shaver says there really is no understating how important this Supreme Court decision was for Native communities really all over the country.
So New Mexico actually passed its own version of an ICWA law last year. So do we know what would have happened had the Supreme Court ruled the other way?
Well, Shaver suggests that it would have been a lot easier for opponents who believe that this is a race-based law to challenge those protections in court. Right now, only 14 states, including New Mexico, have their own ICWA law in place.
Okay, Griffin, thanks for the breakdown.